The Center for Labor and Employment Law at NYU is the organization that is putting out the annual Conference on Labor. Our NYU Annual Conference on Labor has been around since 1947. I was not there at the time. It started with the Taft-Hartley amendments, and we're now into the 72nd year. We're very proud of the conference. We think it's one of the leading fora in the country for studying the workplace. The members of our Center for Labor and Employment Law are representatives of employees and representatives of unions and representatives of companies. It is a balanced organization. We do not take positions. We're an educational organization, and many of the members of the advisory board donate their services to our programs. In addition, we have three folks that provided additional support. I just want to mention them. Organizations. One is the Columbia River Associates. Am I getting that right? And that is a very important consulting organization, and we're going to get representation from them. I'm sorry, the Charles River Associates. I got the wrong river. The Charles River Associates. A very important consulting organization. Jones Day Law Firm. Michael Gray is a member of our advisory board, and the HR Policy Association. I think Roger King is also presenting in this conference, and they're a management advocacy organization, very able one. It's my pleasure to introduce our keynote speaker, our belated keynote speaker, but we're glad to have her, and she is the very talented solicitor for the U.S. Department of Labor. She's spoken here previously. She had a distinguished career as a labor and employment lawyer for Kirkland and Ellis. She's a graduate of Notre Dame. We invite her to receive adoption from us. She is an NYU person because she's now been a speaker of ours. And I turn it over now. The solicitor of the Department of Labor is the top legal position at the Department of Labor, litigation responsibility as well as advice responsibility. Kate O'Scanlan, for you.
Thank you, Sam, for that warm introduction, and I apologize for this morning's issues. Thank you for your patience and your flexibility in the schedule. I really do appreciate it. This year's conference is timely as it focuses on artificial intelligence and automation and the effect that will have on the future of work. Just this morning, I was preparing to come here, and I opened up my iPhone, clicked Uber, and within 5 minutes, I was on my way to this conference. Not even 10 years ago, no one could imagine that an app on our smartphone would have the ability to ping a driver who would be on his or her way to pick up and drive you virtually anywhere within minutes from requesting it over our phones. There's no question that technology has transformed our day-to-day lives. It's transformed our homes and our workplace. It's transformed the way we think, and ultimately, it's transformed the way we prepare for the future of work. Technology change has driven us to do great things. Technology makes our workplace more productive, and productivity is a key ingredient to our national economic growth. Our technological advances make each of us more productive, and as productivity climbs, prosperity follows. This administration and the Department of Labor are committed to ensuring Americans enjoy prosperity. In February of this year, President Trump issued an executive order on maintaining American leadership in artificial intelligence. In the executive order, the administration reaffirmed its commitment to the development and facilitation of artificial intelligence. The executive order states, maintaining American leadership in AI requires a concerted effort to promote advancements in technology and innovation while protecting American technology, economic and national security, civil liberties, privacy, and American values. The Department of Labor in particular recognizes the role that it plays in maintaining American leadership in AI. The issue currently facing the department is how do we upskill workers and take advantage of new technologies? How do we enhance productivity in ways that benefit workers and employers? How do we reach out-of-work people and make them part of the future of the workforce? President Trump and Secretary Acosta are focused on the future. readying the American workforce for changes that rapidly advancing technologies will bring to jobs in the workplace. Simply put, the department is preparing for the future by using every tool at its disposal to encourage the U.S. workforce to develop the skills and cultivate the experiences needed to take full advantage of the opportunities that our thriving economy affords. The department recognizes that as technology evolves, so must its approach to modernization. To that end, I want to highlight a number of initiatives that are underway at the department that are utilizing artificial intelligence to promote workplace safety, to connect job seekers with open jobs, and to ensure Americans have all the skills necessary to thrive in this modern world. The department is also hard at work at modernizing our regulations. DOL is focused on re-examining and rescinding regulations or regulatory actions that unnecessarily restrict individual autonomy and flexibility of businesses. Today, I'll also address a number of regulations underway at the department aimed at modernizing our workplace. So first, let me start with workplace safety. Technology is making our workplace safer. Last year, we saw many new jobs created and fewer fatalities and injuries on the job. The Mine Safety and Health Administration, or MSHA, fulfilled its statutory mandate to inspect all underground mines 4 times a year and service mines twice a year. Notably, the mining industry overall experienced the second lowest number of fatalities in 2018 in its history. In the Occupational Safety and Health Administration, or OSHA sphere, the numbers and rates of fatal injuries and non-fatal injuries and illnesses in the workplace also declined. Fatality rate fell to 3.5 in 100,000 full-time equivalent workers. The incident rates for private industry non-fatal cases fell to 2.8 per 100 full-time equivalent workers after employers reported 450,000 fewer cases. 45,000 fewer cases. Both MSHA and OSHA are utilizing artificial intelligence to promote workplace safety of employers, employees, and inspectors. MSHA, for example, just recently purchased its first aerial drone. The use of the drone and what it captures is targeted depending on the type of investigation or compliance assistance that is needed. For impoundment investigations and assistance, MSHA's Mine Waste and Geotechnical Engineering Division will use photographs taken from the drone to generate topographical drawings. These drawings are then used in certain analyses. These analyses are intended to give MSHA the ability to assess the adequacy of proposed plans to make MSHA aware of potential future problems that should be avoided. Another example is the use of a drone during structural investigations and assistance. The drone is able to obtain high-resolution photographical information from parts of a structure that would otherwise be difficult, dangerous, or impossible to access. MSHA is also testing different technologies that use virtual reality. This type of technology will improve productivity and reclamation efforts. MSHA is using virtual reality technology and training with its students in the classroom at the Mine Safety and Health Academy in Beckley, West Virginia. MSHA also has taken steps towards machine learning, which is a type of subset of artificial intelligence. And using this type of learning, MSHA hopes to develop predictive analytics. For example, the analytics starts with a question, such as, why do certain types of injuries occur more frequently at certain types of mines? The data scientists then clean up the data, eliminate errors, and account for outliers, and then depending on the information they receive, they'll select and apply appropriate predictive models. For example, such insights might include establishing a correlation between a specific type of injury and a lack of training for miners new to the mine, or experienced miners who are assigned a new task. It's worth noting that MSHA does not view these analytics as an enforcement tool. Rather, it's oriented towards compliance assistance and education to identify risks supported by data and share those risks with the relevant segment of the mining community to raise awareness of the risk and potentially take action to mitigate it. Moving on to OSHA. Similar to MSHA, OSHA is also utilizing drones. In May 2018, OSHA issued a memorandum addressing the use of unmanned aircraft systems in inspections. Simultaneously, the department also issued its recommended best practices for this program. Again, OSHA is not utilizing drones for the purpose of initiating inspections. Rather, these drones are being used for inspection purposes, typically when it's been deemed unsafe for inspectors to enter a workplace or work site, and only with an employer's permission. The drones are intended to collect evidence during inspections of certain workplace settings, including areas that are inaccessible and pose a safety risk to inspection personnel. These are also used for technical assistance in emergencies during compliance assistant activities, as well as for training. In November 2017, OSHA announced that it established a 2-year alliance with the Robotic Industries Association and the National Institution for Occupational Safety and Health, or NIOSH, to improve awareness of occupational hazards from traditional industrial robots and emerging robot technologies. The alliance fosters a technological exchange and information sharing among RIA members, OSHA and NIOSH, employers, and workers concerned about mechanical, electrical, and other hazards, and how to best control exposures during operations involving human interactions with robotic systems found in the workplaces then and now. It is this type of information sharing that will better inform the conversation as to how the department is best able to assist the American workforce in adapting and evolving technologies. And just last month, OSHA notified the public that it was considering an update to rules governing the use of machines in the workplace in light of increasing use of robotic technology. The agency said it's interested in comments on the use of control circuit type devices to isolate energy, as well as the evolving technology of robotics. The department is aware robotics play a role in ensuring workplace safety and is interested in hearing from its stakeholders and the regulated community on the best ways to adapt to this role. In addition to using artificial intelligence for the promotion of workplace safety, the department is also using artificial intelligence to connect job seekers with open jobs. DOL has placed a tremendous focus on the American apprenticeships, earn and learn model of training, to get people the skills that they need for in-demand jobs and to lead family-sustaining career paths. As technology is fundamentally and rapidly changing the nature of work, our stakeholders are rightly concerned about the skills gap, the significant divide between the skills that workers have and the skills that available jobs demand. While the employment numbers are encouraging, millions of Americans remain unemployed, even while more than 6 million current job openings go unfulfilled. Secretary Acosta has been at the forefront of proposing solutions to support the American workforce and to close this skills gap. The department is eager to adopt and implement the latest technologies to pair job seekers with open jobs in an attempt to close this gap. An example of this comes from our Veterans Employment and Training Services. Often, veterans may have difficulty translating military skills to civilian skills. The department places a priority on preparing veterans with the necessary tools and training to pursue certain career opportunities. Both the department and this administration place a priority on providing high-quality job training through apprenticeships. Presently, the department is working on developing tools that use artificial intelligence algorithms or natural language processing technology to match veterans to registered apprenticeship programs. By showing the relationship between specific military and related civil skills, digital tools can help veterans understand which civilian jobs and registered apprenticeships match their military skills, helping them succeed in the workplace. As technology evolves, so must the department's approach to modernizing its guidance and regulation in order to provide greater clarity to the regulated community. Our Wage and Hour Division in particular is hard at work on this front. The department continues to use opinion letters as a form of compliance assistance. As many of you are aware, opinion letters are an official written opinion by the Wage and Hour Division Administrator of how a particular law applies in a specific circumstance presented to an employer, employee, or other entity requesting an opinion. An example of the department addressing the modern economy can be found in a recent letter on independent contractors. In April of this year, the department issued an opinion letter addressing whether a service provider for a virtual marketplace company is an employee of the company or an independent contractor under the Fair Labor Standards Act. Although it is very much a fact-specific inquiry, the relationship between virtual marketplace companies and service providers does not always fit neatly into the employer-employee relationship under the FLSA as it's been defined and interpreted for decades. Accordingly, the Wage and Hour Division deemed it necessary to provide further guidance and clarity to employers to ensure they understand their obligations. Under the facts presented by this requester, a virtual marketplace company was defined as an online and/or smartphone-based referral service that connects service providers to end market consumers to provide a wide variety of services. In its opinion letter, Wage and Hour considered each of the facts presented in the request and applied 6-factor balancing test that was derived from Supreme Court precedent. The opinion letter ultimately concludes that these workers who provide services to consumers through the specific company's virtual platform are independent contractors, not employees of the company. The letter further states that the facts demonstrate economic independence rather than economic dependence in the working relationship between the virtual marketplace company and its service providers. The letter was intended to provide insight to ensure that employers who want to do the right thing have clear compliance assistance. Turning to our regulatory agenda, in the Wage and Hour Division, again, a number of regulations have not been updated for years, if not decades. 3 regulations in particular seek to modernize the way in which the department applies the Fair Labor Standards Act. They are the joint employment, regular rate, and overtime regulations. The department, I want to talk to you about joint employment. The department announced a proposed rule that would update the FLSA joint employment regulations. The department had not revised joint employer regulations since 1958. Beginning in 1939, the department recognized that an employee can have a joint employer. And since then, the case law interpreting the Fair Labor Standards Act joint employment has evolved. Circuit courts hold that joint employer status is often an economics realities test that is fact-specific and finding various liabilities circuit by circuit. 4 circuits use a 4-circuit test. 2 circuits use a 6-factor test. 1 circuit uses an 8-factor test. And one last circuit, the 9th, uses a 13-factor test. Our NPRM uses a 4-factor test, but changes the first factor from power to hire and fire to hire and fire. Joint employer must actually exercise control. It's worth noting that this case law is contradictory and confusing, and Section 791.2 is a vague standard. In light of this, in the NPRM, the department proposes a clear 4-factor test that would consider whether the potential joint employer actually exercised the power to, number 1, hire or fire the employee, 2, supervise and control the employee's work schedules or conditions of employment, 3, determine the employee's rate and method of payment, and 4, maintain the employee's employment records. The 4-factor test is the same test as adopted by the 9th Circuit in a 1983 case called Bonnet versus California Health and Welfare Agency. The plurality of appellate circuits, including the 1st and 5th circuits, have already applied either the Bonnet test or have adopted a very similar version of it. Secretary Acosta said that the proposed rules will, quote, reduce uncertainty over joint employer status and clarify for the workers who is responsible for their employment protections. The comment period was recently extended until June 25th, 2019, so we'll look forward to reading comments from various stakeholders. Next, let's turn to the regular rate. The department recently regulated a proposal to clarify and update regular rate requirements under Section 7E of the Fair Labor Standards Act. The FLSA generally requires overtime pay at least 1.5 times the regular rate of pay worked in excess of 40 hours per work week. The regular rate determines how much non-exempt employees covered by the FLSA receive in overtime pay. DOL has not revised these regulations in over 60 years. In its NPRM, the department is interested in ensuring that the regulations provide appropriate guidance to employers offering these more modern forms of compensation and benefits regarding in their inclusion of or exclusion from their regular rate. DOL proposes to clarify that employers may exclude from the regular rate costs of providing wellness programs, on-site specialist treatment, gym access, and fitness classes, and employee discounts on retail goods and services. Payments for unused paid leave, including paid and sick leave. Reimbursed expenses, even if not incurred solely for the employer's benefits. Reimbursed travel expenses that do not exceed the maximum travel reimbursements permitted under the Federal Travel Regulation System regulations that satisfy other regulatory requirements. Discretionary bonuses, benefit plans for accident, unemployment, and legal services, tuition programs such as reimbursement programs, or the repayment of educational debt. DOL also proposes to give examples of excludable discretionary bonuses to clarify merely labeling it a bonus so as discretionary certainly does not make it so. Explain that callback pay can be excluded from the regular rate as long as it's not so regular that it essentially is prearranged. And update the basic rate regulations to change the 50-cent threshold to 40% of the federal minimum wage, which would currently mean $2.90. DOL is specifically seeking comment on the nature of tuition programs provided by employers, other common types of discretionary bonuses that DOL should address, whether other benefit plans should be excluded from the regular rate, and whether the basic rate threshold should be 40% of minimum wage or 40% of the applicable state minimum wage, and whether 40% is even the appropriate threshold. The comment period ended yesterday, so I hope anyone or any of your stakeholders or clients who are interested in this rule that you got your comments in. Finally, let's turn to the overtime regulation. As you all are aware, the department recently issued an NPRM on the overtime rule. And obviously, I'm currently limited to what I can say because we're in open rulemaking and litigation. But under the May 2016 overtime rule, which was currently stayed due to ongoing litigation, the salary threshold would have doubled from $23,660 to $47,476 per year. This was too large an increase to ensure a smooth transition with the broader economy. Thus, that salary threshold has not been updated since 2004, nearly 15 years ago. This administration instead proposes a more common sense increase. In developing the proposal, the department received extensive public input from 6 in-person listening sessions held around the nation and more than 200,000 comments as part of the 2017 request for information. Commenters who participated in the response to the department's 2017 request for information or who participated in listening sessions in 2018 regarding the regulations overwhelmingly agreed that the currently enforced salary and compensation level needed to be updated. The comment period has since closed, and we are working hard in assessing and analyzing all of your comments. So our work does not stop here. This administration continues to look ahead and to the next steps it will take to modernize the workforce. The department's spring regulatory agenda shows a number of proposals demonstrating this commitment. One proposal includes an update to an overtime pay exemption for certain retail and service employees who are paid a commission. Another proposal would target the fluctuating work week compensation option. It would provide employers greater flexibility. It would provide employers greater flexibility to provide additional forms of compensation to employees whose hours vary from week to week. It would provide options to allow an employer to pay certain workers whose hours widely range each week and at half their regular rates instead of 1.5 times for any hours worked over 40. The rule will be aimed at making fluctuating workweek method available to businesses that pay workers with bonuses or other incentives. Currently, the law bars such employers from being paid on a fluctuating workweek basis. A final proposal would be designed to modernize the Fair Labor Standards at Section 3M standards and regulations Section 3M credit allows employers to apply the value of food, housing, or other facilities towards workers' wages. In closing, I'd like to end where we started with the executive order and the language of the executive order, where the president stated that continued American leadership in AI is of paramount importance to maintaining the economic and national security of the United States and shaping the global evolution of AI in a manner consistent with our nation's values, priorities, and policies. As I discussed today, the Department of Labor recognizes its role in ensuring that America continues its leadership in AI and is committed to ensuring the U.S. workplace is prepared to meet and adapt its technologies or to the technology changes that are associated with the future of work. The future of work, it will be one where personal liberty flourishes, creative thinking is rewarded, and opportunities to build prosperity are widely shared. I want to thank you for giving me the opportunity to discuss the department's work that's being done, and I look forward to hearing about the discussions that will occur over the next 2 days among all of you. Thank you again for having me.
Thank you, Solicitor O'Scanlan. It turns out that the solicitor has some time to take questions. So if you have any, please come to the microphone and identify yourself.
Hi, thanks for taking the question.
Sure,
Chris
I
Alper.
was trying to
name,
give
sir?
everyone their time back, but
What's your name?
Chris Alper with Bloomberg Law. I just want to follow up on the opinion letter, obviously
sure.
of interest to wage and hour folks. And as you know, it came after the department revoked the administrator's interpretation from the Obama administration. So as far as I know, the only thing on the record in terms of how the administration will approach this issue in the virtual marketplace is that opinion letter, which is supposed to be limited to the individual fact pattern in that case.
Correct.
So if you're a virtual marketplace employer or a worker who wants to know, am I an employee, am I an independent contractor, it seems like the opinion letter is the only thing that you can look to. So should we be considering that as a larger policy statement, at least with respect to this 6-factor test?
Yeah, I mean, I think in terms of the factors, yes, but I also think the opinion letters are meant to only, to the
Right.
very fact-specific inquiry, but I think people should feel free to use that as a vehicle to get better advice and otherwise contact the Wage and Hour Division. Now we finally have a confirmed administrator who is really hard at work and doing an awesome job so far, and I think that there's other ways that we're helping with the compliance assistance. So I think we, again, employers who are interested in making sure they are in compliance, we are there to help. So I think that's very much the outlook from this
I
administration.
can just add one point. The opinion letter is not a regulation,
Nope.
so it doesn't necessarily affect private litigation, nor does it necessarily affect Secretary of Labor's litigation. It's
Yeah,
some-
it gives
it's-
give a good faith
it-
defense for.
It's a guidance, and it provides a good faith defense.
Right.
Have you had a case in which you found that a virtual marketplace is a traditional employer and that workers are employees?
Has the
Not-
Department of Labor found?
Yeah.
What is a virtual marketplace, by the way?
Should ask
Well,
my
that's
New York
that's
solicitor
their
who's in
phrase.
the,
I
who's in
call
the
it
audience
the gig
here.
economy.
Could our New York solicitor come forward and define it for us?
Jeff, do you have any cases that have examined this issue? I'm not aware of any, but I certainly.
Come to the microphone. And identify yourself. We're videotaping this. We're
Best way to
collecting,
handle
we're
Q&A is
collecting
to make
data
someone
that we
else
don't
answer
want
your
to pay
questions.
for. We are videotaping
You know,
this. Go ahead.
usually we're cautioned about making sure we get clearance before we talk to the press, but since my boss is right here, I guess I'll feel free to weigh in. You know,
We're waving caution to the
yeah,
wind.
I guess I am. You know, I guess what we would say about that is, we have a number of different matters that are being investigated.
Yeah.
So they're at all different stages, and as Solicitor O'Scanlan pointed out, while everything is very fact-specific, we are applying the guidance that we are given, and we are trying to make a reasoned, factual-based inquiries on everything that we see. So, as you can imagine, there are lots of different cases currently working their way in. So there's lots of things that are in the department's purview.
Thank you.
Did that answer your question in large part, in substantial? Any other questions or comments? I have one on the joint employer standard, which I have not read, and I apologize. The Labor Board is working on a joint employer standard as well, And it's a big
Separate.
issue. Yes, it's separate. It's a big issue whether it's actual power or the right, is it actual control or the right to control? The DC Circuit sort of slapped the wrists of the NLRB in an earlier case, saying, you've got to follow the common law. I actually have had a student look at all of, very able student, look at all of the common law decisions, not labor board decisions or DOL decisions, to see whether these common law decisions support the right to control language, and I think it does. I mean, so, now, it may be different for the Fair Labor Standards Act, because there's a, you know, it's arguably a different definition of employee. You have any thought about that?
Right, well, I'm a little bit limited what I can say because it's open rulemaking.
I see, still, I
But I
got you.
think what we have proposed is to ensure that among the 6 factors that control is very much a part of that, to sort of get at what you were addressing, some of the mismatch.
Right.
And I don't know, did I read somewhere that the board had put that on the long-term agenda, so that's not as imminent, or am I confusing?
We will
that?
ask John Ring or Peter Robb, they're going to be here. They'll tell
Yeah.
us. But I think there's a problem that the board has in light of the DC Circuit decision that they have to follow the common law, which seems to embrace the right to control. There's
Right,
another.
yeah, but you're right, that 2 different statutes.
There are
and
2 different statutes.
2 different
They
regulations,
might be
2 different
analyzed differently.
standards, so, yeah.
There's also another issue that came up in the McDonald's litigation, and that is, what if you have a franchisee who's solvent, who did the underlying events, committed the underlying events, who is solvent, and therefore could reinstate the workers involved or give them back pay and front pay? Should there be some sort of criteria before you can bring in the franchisor or the parent? In other words, whatever the definition of joint employer doesn't necessarily mean that entity should be immediately suable. You see where I'm going? And is that something that might be discussed in the rulemaking? It's not in your proposed rule. I'll have to put it in the comments.
Yeah, get your comments
What's the
in.
date again?
Is that June 25th? So you've got,
Okay. I'll
it's
try.
10 days,
There are other
so-
things on my plate, but I will try. Yes, please identify yourself.
Hi, I'm Lauren Weber. I'm a reporter at the Wall Street Journal. In terms of artificial intelligence and the effect on workers, we have a trade adjustment assistance program to help workers whose jobs, who've been displaced by globalization and outsourcing. Is there any thought to doing something similar with automation to assist workers who are displaced by automation?
So that's an interesting, interesting question. It's certainly, in my capacity as a solicitor, that I'm not aware of that issue, but that's something I should bring up to the secretary and see if he's got other similar comments, because it's interesting, it's an interesting thought.
The trade adjustment program is a product of statute. That doesn't mean it can't be done administratively, they're a product of statute. They've also not worked that well because it's very hard to prove causation. Why is someone losing a job? Is it losing a job because of trade? It may be, the traceability problem may be easier in the AI context, but it may be something to think about in terms of proposed legislation, mitigating measures, which we're going to talk about shortly. Thank you, Lauren. Other comments or questions? Please come to the microphone.
Hi, Rob Siemens from NYU Stern School of Business.
The other school.
One of the many other stellar
Yes, yes.
schools within this stellar university. Thanks very much for your presentation. You outlined many of the different ways that the department is working to reduce frictions in the workplace, including sort of use of AI to help train and match potential workers to jobs, reducing regulations that might provide friction, create frictions and things like that. In the prior panel, 2 concepts that came up, and I don't know if this falls under what DOL can do, but I would just be curious to get your take on this. So occupational licensing and non-competes, right? So people typically talk about these as, while there might be some benefits in some cases, they create a lot of frictions in the workplace in terms of employees switching jobs and things like that.
Sure.
Is there any, can you say a little bit about what you guys might be doing on this?
Yeah, I think that Secretary Costa is very interested in the occupational licensing issue, and particularly as it relates to military spouses.
Yeah.
So through our veterans, because obviously these are done at a state level, so as the federal department, we don't have this it's not completely in our purview, but we do have certain, through our vets programs, we have initiatives and have the ability to try to influence programs. So that's something he's spoken a lot about in the veteran spouses context, because again, your spouse is moving maybe against his or her will, and all of a sudden, if you could be a teacher, you could be a hairdresser, you could be a lot of different occupations, that it's a pretty high barrier to entry, to move states and then have to pay $3,000 or take classes or whatnot. So I think we agree that it can be a real obstacle to the workplace. And the non-compete issue is I know other friends in the administration at DOJ and FTC are very much looking at those types of issues, which is a little bit more on their purview, but I agree that I think people are seeing that there's at least a sentiment that that's a restriction on, ability for people to get jobs or to market themselves or whatnot, and that can have an ill effect, but that is not necessarily in the, precise jurisdiction of the department.
Sam, am I allowed
Please,
another
please.
question?
Yes.
Okay.
No.
So totally different topic, but
Okay.
this is more sort of building off of the president's quote here.
Sure.
But sort of related to the retraining piece. So to the extent that retraining could be, let's say, like remotely delivered, like an AI tool of some sort that would help a potential employer find a job. It strikes me that one of the barriers is just access to the internet to begin with, right? And so as of, this is perhaps a little out of date, but as of 2016, if you look at income quintiles, right, by family, household income quintiles, the bottom income quintile, only about half of those households had internet at home, right? And so those are arguably the people that you're most trying to reach.
Right.
And so if we're starting to rely even more on sort of digitally delivered tools, that helps those of us that have access to this stuff, but
Right.
how do we handle those families, those households that don't have the access?
Right.
And again, I realize some of this might not be under DOL, this might be more
No,
like
exactly.
an
I
FCC
think
issue.
I think it's an important. I think it's a apt observation. And I think obviously there is a problem. And I know in some of our other modernization rules, we've looked at this insofar as even applying for certain visas or things, saying, hey, if we're trying to modernize and reduce paper, but you also, like you said, you might also in turn then be alienating certain people who don't have access. And I don't know. I don't know enough to. Are people who don't have internet, are they utilizing their public libraries, or is that, I just don't, I would just be sort of speaking off the cuff and unintelligently about that, but I think it's something to think about.
Thank you.
Thank you.
You made a point, Kate, of saying that you're not currently using AI to identify the companies selected for inspections. Is that something that might be revisited? Because employers are using AI to some extent.
Sure.
As a predictive tool.
Well, I think it's hard to say across the board because we want to make sure that we are in our statutory
Right, of
authority
course.
and give the requisite notice to employers or
Right.
make sure we're not running afoul of another
You'd have to do
law,
all of that, yes.
to do that.
Right.
And so that's sort of why I wanted to point that out because I think that I think employers, if you get claims that we're spying on people or whatnot, or using tools, without
Without
giving
a-
fair
a
notice or
cause
whatever the
predicate,
statute
yeah.
may require, that people have concerns about that. So we're trying to
Right.
balance
Right.
those two things when, but particularly, in OSHA and MSHA, I mean, there can, with consent and whatnot, I mean, you could send in for data, you'd rather lose a drone than you would put somebody's life at
Right.
issue. And so some of those things, I think people are being creative for areas where it works, or really, aerial views and things like that make a lot of sense. But I think we want to ensure employers, though, that we're not, again, overly spying or going outside what we're allowed to do, permitted to do under the law, because we try to be very upfront and legal in our investigations. So.
Is there any work being done on the affirmative action executive order, which is in your purview?
What do you mean by, is there any work being done?
I mean,
on it?
any new thinking that's being developed, or?
Not that I can discuss,
Okay.
but
That's a pretty good answer. I'll stay with that. Any other questions or comments? I don't see any. Please thank our solicitor.
thank you.